Yes, ma'am. You can start.
Okay. Good afternoon, dear participants, and welcome back to the session 2 of this International Faculty Development Program on the disciplinary perspectives of international law. So today I have the great pleasure in welcoming Associate Professor Dr. Dennis Agelebe to deliver his lecture on international economic law. So just to give you a short introduction of Dr. Dennis before he begins. So Dr. Dennis is currently a postdoctoral fellow at the Open Africa Innovation Research Network in the Center for Law, Technology and Society at the University of Ottawa, Canada. He's also a senior research fellow at the Environmental Law Center of the University of Cologne, Germany, and a member of the Legal Advisory Board of the Center in Germany. He's also an associate member of the prestigious think tank research center, the Global South Studies Center of the University of Cologne. He holds a Bachelor of Law degree, an LLB, from the University of Calabar, Nigeria, and an LLM in International Human Rights Law and Environmental Protection from Charles University, Prague, the Czech Republic. He also earned a doctorate in law, specializing in environment and trade law from the University of Cologne. Beside the Czech Republic and Germany, he has research experience in New Zealand as a University of Canterbury scholar and in India as a DAAD visiting scholar. So before going into academia, he was called to the Nigerian bar as a barrister and solicitor of the Supreme Court of the Federal Republic of Nigeria. He practiced as a lawyer at different times in Abuja, Nigeria, and in 2020, he led the UNDP CHEF-funded project for de-risking renewable energy in interconnected mini-grids in Nigeria, while working as a senior fellow with SD Strategies in Berlin. He's an expert in African law, and he is very famous for having convened the first African Environmental Law Conference in the Environmental Law Center at the University of Cologne and the lecture series on climate ethics in Africa. He is also the recipient of several Research Scholar Awards, including the prestigious Queen Elizabeth II Scholars Award. He is also the editor for the International Journal of Health, Education and Environment and has published academic research papers in several international journals. His research interests include emerging technology, sustainable development, renewable energy investment, environmentally trade practices, and foreign direct investment with environment ethics in developing countries. So welcome, Dr. Agelebe. A real pleasure for us to hear from you today and to share your expertise with all our participants. The floor is yours. Thank you.
Thank you very much for that introduction, Dr. Bhavna. I was almost wondering if I'm the same person we are talking about, but I am the person. Thank you very much, colleagues. It's an honor to be part of you today. I wish I was able to join yesterday to also learn from those that were part of the program yesterday, but it was very tight for me to join. And every of my colleagues, honestly, I count it. I'm not taking this time that you are taking to listen to me for granted. And I want us to take this period to be a two-way traffic between me and you. I'll be talking about international economic law, but in a direction that intersects with sustainability, the concept of sustainability. And it's because we constantly see the tension between satisfying the economic pressure on developing and developed countries with the need to take the path of sustainability. It's not because sustainability is more expensive. It's because economic system, the imperative the imperative culture of we pursuing more money, pursuing more standard of living that is quality for our people, and even the pressure on government to ensure that they satisfy the needs of everybody. When you try to copulate it with the growing pressure to sustain the environment, to sustain even the living of we humans, and ensure that the environment that we live remains where we can live and still live it in a sustainable manner for those that are coming after us, it becomes a very tense issue for political leaders, for scientists, for policymakers. And we teachers of the law, we trainers of future lawyers, we experts, we lawyers, we are the front line. We may not be part of those that are, following the nitty-gritty of the science of it. But the theoretical framework, the legal skeleton, the legal structure that upholds all the flesh and all the other issues that comes into play, we brainstorm about it, and then we push for what we think is just for the politicians to implement. So that's why today I want to delve into what's our perception? What's our perception about how we are growing knowledge as to the intersection between economic law, international economic law, and the concept of sustainability? And also, how do we really balance the way of liberalization? I don't want to use commercialization. I prefer to use liberalization because the open market system that we are pursuing, that most developed countries and even developing countries are pursuing, really exposes the planet beyond the boundaries of what sustainability entails. Let me see. I'm having some issues with changing my slide because my mouse is, I don't know, sorry. So just give me some minutes to do this. I wish I can just, okay, good. So let's examine the tension. Let's examine where are we experiencing the strain. The conflict itself is not in the practice. It starts from the formulation of the policies that accommodates regulation of the economic space. So before we start talking about sustainability, environmental conservation, and all that, the global economy is used to just thinking about one thing: growth. Growth. Growth of what? Growth of the economy, growth of revenue base, growth of infrastructure, growth of what makes money for people, growth of what allows people to make money, growth of freedom, increase in participatory rights in the business sphere. Regulation is not about how are we looking at the quality of even what we are growing. It was just about growth. So now that we are talking about sustainability, it becomes a kind of tense issue for policymakers and those that decide. So if we look at the dynamism of economy on its own, especially the modern global dynamism economy, the governance of it is more attractive. It's more attractive to politicians that want a liberal system, politicians that want less regulation of the market, less or weaker regulatory structure of the market system in favor of all commerce come, make money, grow the economy, strengthen the financial clout of the people, but then do as much as possible to look away from the cost that comes with that. So where do we get that intersection between what we see as the conflict and what we see as the leverage that we should allow to play for liberalization or for regulation? So do economic rules, standards, does it really restrict a state's right to protect its environmental system, its environmental interests, its environmental concerns, and the concerns of the citizens? Is the law itself designed to create barriers for protection? If it's designed that way, what is the argument of the legal minds that collaborate with politicians in framing such a system or framing such a regulatory structure, a legal structure? So this intersection, we are going to look and explore the legal, the financial, and the political tensions that arise in a situation where we push for a free trade, investment, and then try to accommodate the need for environmental protection and climate action. The fundamental conflict, how does it also mirrors the goal of international environmental law? Well, international environmental law looks at the promotion of free trade, the protection of investments that goes into the promotion of free trade, and looks at how the framework, the legal framework, allows for financial stability, how the different segments of the economy, how they interplay without causing a commotion, an economic commotion. For example, during the COVID-19 pandemic, we saw the struggle between satisfying the health needs of the people, between focusing on the health and purity of the people, and pushing for economic growth. It was a great struggle. And that's why you see developing countries, they were not having a kind of consensus added them on what is the approach. Should it be total lockdown or partial lockdown? It's not about anything. It's not because they don't believe there is a need for strict rules, not because they don't believe that there is a need for drastic measures. It's simply because, how does this satisfy the structure of our financial stability? And then they will look at, hey, we just opened our market to investors. We just started the project, what's trillions of dollars, billions of dollars, and we've had forecast. COVID wasn't part of the forecast. So how do we move from here to there if we shut down our economy? The need of the state struggles with the imperative of protecting the health of the people. Same thing when it comes to conservation. So the goals of international environmental law, in terms of what it entails versus the needs of the states in terms of how they frame climate measures, how they even implement these measures. Why did they even frame these measures? Do they think that they are at the point where the health of the people, the conservation of the ecosystem, that are already sitting at the fringe of extinction in some cases, is what they should take as a priority? Well, in defining this, we now have a picture of the conflict itself. We now have a picture of what that conflict covers. Because we now know that, well, if international economic law is primarily made or designed to liberalize markets and protect investors, and today we have to now think of regulating some very core segments in terms of how do we, to what extent do we pollute the environment, because polluting industries are bringing so much into the economy. And then what are the instruments? Should we enact carbon taxes? Because all these, they are interplaying with the laws that governs the economy. So they are not in isolation. It's not possible for us now to be playing the protection on one side, on one field, and be playing the promotion on another field. So we now see that we are being innovative in coming up with instruments that helps us to navigate that interplay, to navigate the same space, the same economic space, the same field now, and possibly. Sorry for that. Sorry for that. I'm very sorry for that. And achieve the same goal of sustenance. Please confirm you can see me, because I don't know if the call distorts my system.
No, Dennis, everything is fine. You can continue.
Okay, thank you. How are we moving progressively? Progressively, but with a sense of conservatism. So the instruments that have been introduced, they are allowing policymakers to find that space. And most times, the level of innovation also is giving hands to regulations that we do not know, like maybe 15 or 20 years ago. How are we going to even get something from regulating the level of emission that is allowed? All these are necessary so that we can see that violations of trade or investment treaties in ways that they create legal conflict in the past is not in the same way when we merge the interests of the environment and the interests of the economy under one system, under one jurisdiction. So we are essentially dealing with a system, a legal system that we are used to, that needs to accommodate new global crises, new global realities, from the front of the interest of the economy and also from the front of the interest of the environment. So sustainability as a framework, bridging that gap between the need for the economy and the need for conservatism, started growing in prominence since 1987. And gradually its growth starts getting to the point where it's balancing the economic, the environment, and the social pillars that sustain the society. So while international environmental law originally focused on, maybe let me say 100% on the economic pillar, now the reality is that the challenge is there for how do we reform trade and investment rules so that trade and investment rules become enablers of environment. They are not going to be risk factors. They're not going to be seen as antagonizing the interests of the environment and social well-being. of the people. They're not going to be seen as fundamental attackers, if I may use that word, of the concept of social sustainability. And they will also not become necessary obstacles to the growth of the economy. Because if you ask policymakers and you even ask lawyers that support economic policymakers, they will tell you that, well, to them, it's as if the concept of sustainability is becoming a barrier to growth. If you want to delve a little bit out of legal argument and go a little bit to the political argument, I mean, it's clear for us to see what's happening in the United States of America. We had the era of George Bush, that is a conservative president with an environmental, or let me say, climate progressive mind, climate change progressive mindset, and enacted some policies, introduced some policies that supports the argument that we should start taking actions, especially the country of the United States of America should start taking actions in the interest of protecting the environment, not just the environment in America, but even global interest, because America is a net emitter of greenhouse gases. But then Obama came and strengthened the fabrics, the regulatory fabrics that pushes for a more sustainable and conservative agenda in terms of environment-wise. Compare the approach with the approach of Donald Trump. Donald Trump he's on the extreme. He's a no-no. And he is not shy about it. He has been outspoken about this. This is what I think about the whole thing about climate change. And actively, legally, constitutionally, if I may use that word, dismantle every instrument, legal instrument that his predecessors have put in place before he came. So the politics side of it, the legal side of it, if we say that it's in favor of the argument of both working together, we'll be wrong. Because these three pillars we are talking about, economic growth, environmental protection, social equity, so far, the developed world, they talk more about economic growth. It's only when maybe when you have more of the events, strong events coming, or maybe when there is a kind of natural disaster that can be accrued to climate change issues, that you hear them talk. The truth is, they are more preoccupied with economic growth, fiscal and issues that pervades their own economy and jurisdiction. International environmental economic law serves as a tool, or we are pushing, those of us that we think that it's being reformed. It's no more talking about 100% economic growth, but being seen or being transformed or being reformed to serve as a tool to integrate and balance these three pillars. These three pillars exist. The challenge is finding the balance. So when you look at the Sustainable Development Goals, all the goals that we see here, hardly you see any country that is pursuing any of them with just policies, except those that are the pretenders. All are being initiated and implemented via legal frameworks. Well, to a large extent, or to some extent, there are some instances where the kind of legal framework that some countries put together may just be just be kind of a conventional action, just be kind of to satisfy a political agenda. But whatever it is that you call it, a law has been made. Now you see over 90, let me say over 129 countries, if I'm correct, over 129 countries so far. The last time I checked, about 119 countries have established climate change commission. And if you look at the structure of the laws, the content, you will sense something. You observe something, that there is similarity in the content, there is similarity in structure, there is similarity also in even the establishment of the structure of the established commission itself. That points to something that they are following conventional agreements. They are following recommendations, international recommendations that says this should be established and this is how it should be, especially the developing countries. So international economic law is seeking to actively support these goals. However, the narrative, even the context of the support, from the point of we that are teaching law and those of us that we are grooming future lawyers, the argument is not so strong enough. Why? Because the curriculum we've been operating has taken so much hold of the aspect of trade and investment. And also because the innovations that we are seeing now, the kind of startups, the kind of enterprise businesses that we are seeing that goes into sustainability, they are so novel. And in some cases, they are still testing the law. And the law is still testing some in some countries. Yes, the business of recycling waste, of course, there are regulations for that. The business of converting what used to be pollution to usable gas, there are laws for that. But then you are seeing new areas that the legal system is still finding a way of accommodating them. We are seeing new areas in which some countries, they are looking at it and saying, if we accommodate this kind of business and this kind of business, or make regulations that we allow the operation of maybe hydrogen, it could affect as a source of energy that is sustainable for usage. It could affect some other things. It could affect our water reserve. It could affect some other things that we don't want to take a risk of making it let our economy to go down. For example, now we're talking of rare earths. We're talking of the elements and the resources and the kind of earth resources that we use to produce lithium battery. And then because technology has made us, I'm just as an example, technology has made it possible now for us to store electricity in this kind of high capacity batteries for longer hours, providing stability for energy generation and energy distribution. The question is this: we are going to make money from producing these batteries. These batteries are going to help us to promote clean energy. However, at what cost? At what cost to the environment? So you see the tension. Finding that balance has always been an issue. Okay, there is technology for having the cloud system for artificial intelligence. This technology relies on a huge amount of electricity. Where are we getting the electricity from? what do we think can sustain that kind of level or that kind of consistency in supply of electricity? So the law is still testing these innovative ideas, and the innovative idea is also taking advantage of the space where political leaders, economists, they say, because these are novel ideas, let's not talk about sustainability now. Let's not talk about the interest of the planet now. Let's just talk about what will these ideas bring to the economy. Well, once we ascertain that, we are going to come back to talk about how is this business affecting the environment? What's the long-term effect of this kind of business on our planet? So that's where we found ourselves in terms of the confusion of merging the mandate of economic laws with the interest of pursuing sustainable development. So let's look at the pillars of international economic law and sustainability. First, the international trade law aspect, the international investment law aspect, and then the financial law and the transition. The transition in this context now is the transition moving from fossil, let me use the word fossil powered economy to a green economy. And how is the financial system accommodating that transition? To what extent? And what are in place for the financial system to really transform to the point that what we see as embedded instruments now, like the green bonds, carbon trading system, taxation of carbon, will not just be embedded, but will become fully integrated to even decide the direction of the financial system. So, well, international environmental law getting to that point depends on what we are doing now, not just on the policymakers. No, it depends on we, the teachers of the law, we, the lawyers, talking to those that are on the front line of interacting with the politicians. Because the politicians, they are more familiar with the WTO rules, investment laws, investment treaties, the energy charter, and all that. They are more familiar with those languages. Yes, they keep hearing sustainable development, climate change. They keep hearing those things, but you see, to them, to some of them, it's just like the theory. And forgive me if I digress a little bit. That is why when people travel from different parts of the world, different countries, from 200 countries to attend the COP every year, and then they issue the communique, what do you hear? You hear statements. You hear statements that makes you to feel that something is happening. But 1 year down the line, the question is, what is changing? At the end of the day, after the COP conference and everybody goes back home, it's about the economy. It's about investment. Why? It's not because the WTO is not fair enough, in terms of what it should accommodate from the context of conservation. It's because it also allows them to decide whether they should integrate or not. So we will say that it creates a level playing field. That level playing field that the WTO principles create. That so-called don't let me use what so-called, let me be respectful. That's non-discrimination principle. He said it's meant to treat all trading partners equally. It's not about giving them the equal space to integrate their environmental concerns and the economic concerns into one same field. So the problem is seen most time when we introduce environmental measures, and we want to bring those environmental measures not with the banner of these are environmental measures. We introduce them with the banner of these are economic measures to protect our own economy from being exploited. So when we do this, we say that we introduce product standard, carbon taxes, but these are often seen as non-tariff barriers that violates the same WTO principles that are, giving the credence for creating a level playing field. That alone makes the WTO not be the instrument that we should rely on for integrating sustainability into economic concepts, economic measures, and then even have the confidence that if dispute should happen, we can go back to the same WTO and say that, well, this is the defense that we have for introducing these measures of our environment. Yes, there is the SPS treaty that we've had arguments forward, backward. That's okay. Maybe this one is a form of protection under the WTO jurisdiction in the interest of the environment. But the truth is, all the cases that have come to the WTO under the SPS treaty, most of them, they are not, it comes by way of protecting the health of the people, but not the environment per se. So it comes under the banner of protecting the health. The reason why we get excited about, for example, the EC Mons case is that, well, the environment is a huge factor in producing the issues, or let me say, producing what we think determines the health of the people, the healthy living of the people. So based on that, we're happy and we celebrated the case. However, talking about WTO principles, strict WTO principles, the principles are not receptive to introducing environmental measures. So it is either we look away from it and look for something stronger, come up with a stronger treaty that will not displace WTO as a body or as a system, but we safeguard the interests of those that are in the WTO, under the WTO, whenever issues that has to do with disputes between them and their counterparts, and it is purely based on environmental interest versus economic interest. Perhaps they will have, or hopefully they have, a better deal compared to if they are under a WTO, where they can't have guarantee that the interest of the environment will be a factor, or a strong factor. It will be a factor, but a strong factor that will be considered when there's a dispute in terms of measures that introduce tariff or non-tariff measures that introduced as a member of WTO. So, well, WTO under the WTO instruments, there are provisions. There are provisions that are already embedded in the system that allows you to raise exceptions to you fulfilling your obligations under the WTO. For example, under the, please, are you still following me? Can you hear me clearly? Hello? Hello? Wow. Have I been talking to myself?
Hello,
No,
sir.
hello, sir.
Hello, sir.
Can you hear me?
Hello, sir.
Hello,
Yes,
sir.
yes, we are
Yes,
hearing you,
we
sir.
are here, sir. We are listening
Yes,
to
sir.
you.
Hearing you clearly.
Okay, because I was wondering, that I was scared that I hope I've not been talking to myself. I've not seen myself because of the interface of my screen and the, what is it
Sir,
called?
this is one issue
Yeah.
with Google Meet. You cannot see the interface while presenting the screen, sir.
Sir,
Okay.
sir, we are hearing you, sir. Your lecture is very well, sir. Continue.
Okay, thank you very much. So I'm trying to see if I can pull up the exact provisions and maybe make exact quotes. So just give me a few minutes, please. Just a few seconds further. As it access, I should have put it on the screen, but it's so extended. Article access. Let me see. Okay, the general exceptions. Okay, so well, under the general agreement on tariffs and trade, Article XX provides the general exceptions that allow states to derogate from their obligations under the WTO rules. The argument has been that these obligations, they are for specific public policy reasons. But then, if you say specific public policy reasons, are there ways where we can bring environmental interests under any of these reasons? We have, several provisions here that one could make reference to, and one could provide arguments that could come under a form of justification why we should bring environmental interests arguments into play. The issue is this: if states are restricted to being strict to what is known as the two-tier test to use this defense, first, at the time when we agreed on this treaty, the level of sophistication of environmental argument is not as strong as it is now. And I don't think it's within the contemplation of the drafters of that agreement that we will get to the point where we are now with the argument about climate change and sustainability. Yes, they were visionary. And we give credit to them for the fact that at least we're able to come, to bring justification under certain specific paragraphs, either by way of, okay, how is this going to be the interest of the health of the people, either by way of how it's going to be the interest of, majorly people talk about the health of the people, and they don't want to mention the environment. And as I said, same reason why we had the argument with the ECOMOS in the ECOMOS case. that we cannot talk about the health of the people without talking about the environment. But then, what about business practices? Business practices that are inimical to the health of the people. What about even the substance of the kind of practices that the economy allows because you are at a certain level of development? And because you are at a certain level of development as a country, you must relax some certain rules. Or not that you must, you are allowed to relax some certain rules as an exception. So we lawyers and teachers of the law, some of us have argued that, well, we can use these general exceptions as an argument to say that the WTO principle, to a large extent, have allowed compliance, have allowed integration. But we know that because of the specificity of the paragraphs that are allowed, I'm sorry, I have a challenge. I'm trying to read from my phone. It's tiny, so I have to remove my glasses to see my phone. I will have to put on my glasses to look at the screen and see generally. There's specific paragraphs that I wanted to make reference to, which I can't just put on my screen because of the interface. It says, subject to the requirements under a general exception, subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. Nothing in this argument shall be construed to prevent the adoption or enforcement by any contracting party of measures. Now, A, necessary to protect public morals. This is where I'm going to. B, necessary to protect human, animal, or plant life or health. Paragraph B. There are other paragraphs that I could try to connect. I think, but most times we make reference to paragraph B, except we come down to the scope and the application, where we try to bring out interpretive arguments. Now, if you take notice of the main factors mentioned here in paragraph B, necessary to protect human, animal, or plant life or health. This gives us a leverage. It gives us a leverage to integrate measures. However, that leverage is not a blank leverage, because you need to look at the introductory part that provides the conditions under which you could introduce these measures. So it's like in the paragraph, it's like they're giving you with one hand, but the foundation itself, the introductory foundation, is taken from you or putting you in a state where we are not really looking at the best or looking at what is fundamental in your interests, which is the health of your people, which is the plant life, which is the animals, the health of the animals, the kind of things they eat, the kind of substance that you allow your business people to import into your country, or your farmers to import to your country to feed your animals, and how those substances will affect the health of your people. Okay, so we had issues of scientific arguments. How do you even justify? Because, I mean, definitely you are going to bring up scientific argument to defend why you're introducing this measure. Then we will now raise issues of the fairness of that science, the acceptability of that science, which kind of tests that science has passed through. Which kind of body? I'm trying to just draw from the SPS treaty now to the conditions and even the decision of the WTO under that's emanated from the ECOMON's case. Several factors. And you can imagine that if the European Union themselves struggle to even present cogent defense for themselves to protect their interests, to protect their environmental jurisprudence, we developing countries, tell me, how possible will it be for us to have argument that is strong enough to justify measures, environmental measures that developed countries or even co-developing countries we see as countering their economic interest? So my take on this is that the WTO jurisprudence, on the surface of it and in some certain areas, allows us to integrate sustainability. But that leverage is outdated and is not consistent with the current realities. So because why? You look at the requirement. The requirement is that the least rate restrictive alternative, that's, I mean, which forms part of the introduction. You know, that requirement, it doesn't achieve the desired level of protection. And then the burden, the defending states will have to demonstrate so much to show that, look, this measure that we are introducing, we don't have any alternative to it. To show that, look, this measure we are introducing is not restricting trade. It's simply protecting the interest. Even if it's restricting trade, it is justifiably restricting trade. Well, the concept of liberalization doesn't want to hear that. Doesn't want to allow any excuse for that. And that is why the necessity test is very, very burdensome in integrating sustainability with liberalization of the economy. So the other argument will be the autonomy of these economies. To what extent are international economic laws allowing treaties, bilateral trade treaties, multilateral trade treaties, to restrict the states from regulating their conservative interests, from regulating their environmental interests, from regulating their sustainability interests? Because these treaties themselves, they are not pro-environment treaties. You will not, yes, we know that multilateral environmental agreements, MEAs, that countries have entered into, that to a large extent integrate economic interests into what they do. But the problem is they mirror these agreements with substantive rules under WTO and other international investment laws. So that's the challenge that we have with that, proving the necessity of the measures that we are introducing. I mentioned the ECOMON's case. There's also the US import provision of certain shrimp and shrimp products case. The ruling in this case is they go almost same direction. The WTO appellate body ruled that exhaustible natural resources, including living includes living renewables, as e.g. sea turtles, and global common resources. Well, this ruling, it makes us to have the understanding of what WTO can accommodate. That is, it actually has the capacity to accommodate environmental concerns. If the WTO system is not accommodating concerns, is simply based on the politics of WTO, not because the legal system itself cannot. Yes, we know it's a system that needs reform. We know that the substance of the laws need reform. We know that the substance of the laws, they are not designed to actually integrate fully environmental concerns. But it's not that it's not possible. It's not that the capacity is not there. Because it evolves, it keeps evolving. And as new issues still keep coming, the players in the system, they have capacity to find a way to accommodate these issues. So we are seeing evolutionary interpretation of these issues. But to a large extent, we've not seen anything new other than these same old cases that, we've had in past years. Maybe if we allow, when it gets to the 1 hour mark, maybe we take a few discussions and then we continue, or we wait until after lecture, then we continue discussion. Which should we go? Because
I believe you end the lecture, Dennis, then we'll have the question and answer session, right?
Okay. Thank you very much. So I don't want to rush past, because I told my host that I really have a very tough issue with time. I'm sorry about that. So then let's move to the tier 2 level of passive protection, if I may call that, the CHAPO. It says that the measure must not be applied in a manner that constitutes arbitrary or unjustifiable discrimination or a disguised restriction on international trade. I think I've touched on this already. So, I mean, what it's looking at now is not the cost of the measure. So even if your measure is for a good cause, then he's talking about its application. The argument of we lawyers is that, well, if the application of a measure is for a fundamental cause in the context of what is involved, and what is involved, life is involved, the future of generations coming ahead of us is involved. So how fair can we apply it? If I'm the Prime Minister of India, and I feel that, well, I know we have a large population, I know we have more food, but we need more food to come to the country. I know maybe we are not producing enough, but I think I will feel safe with us consuming only what this particular food that we produce. We consume only rice. Rice is staple food, so we consume only the rice that we produce. I don't want rice to come from Thailand into India, because I think they are using certain kind of chemicals that is not good for the health of my people. Well, is the health of my people. How fair do you think I should apply that measure that will make sense to a liberalist? That is where we have problem with the application of WTO rules. So the rule knows that the measure you want to apply is for a good cause. It is not for a malicious cause. And the law allows you to introduce such a measure. But the law is saying that how you introduce that measure should be interrogated. So to what extent can a state exercise autonomy, absolute autonomy from economic treaties that binds it in its application of measures that promote sustainability for its people and the entire ecosystem of the country. Those are the issues we are having with the strict application of the chapter under the GATT. Another issue that came up, which is also novel, and I remember I was still teaching as a full-time professor at Jindal Global University when the EU carbon border adjustment mechanism came up, and I had a very interesting discussion with my students about the application of the carbon border adjustment mechanisms. This mechanism, introduced by the EU, taxes imports based on embedded carbon. It places a ceiling and says, look, if your product you are importing to the EU is linked to a certain level of carbon that was produced, then you will pay a certain rate of tax. Now, the question is, does this prevent carbon leakage? Under paragraph G, or is it unjustifiable? Unjustifiable discrimination under the chapter? Paragraph G, if I may read, says here that relating to the conservation, that's part of the exceptions, relating to the conservation of exhaustible natural resources of such measures are made effective in conjunction with restrictions on domestic production or consumption. For those of us that criticize the CBAM, at that time, we were questioning what is applicable. What is applicable under the domestic system in the EU? Because at that time, the EU, before the Ukraine war, they issued the Green Deal, they celebrated the Green Deal, and I mean, they said all kinds of things about what they think the deal should mean to the continent. But then Ukraine war came, and then they saw that, well, they are not getting the cheap gas that they usually get from Russia. And France first started making some adjustments to what they think the Green Deal means, which up to now is affecting what they call the baseline for carbon production, carbon emission in the EU. And then we are asking that if you are going to tax people, African countries, Asian countries, based on the carbon production that is tied to the products that they are importing to the EU. And yet we are talking about what is fair. We are talking about what is not discriminatory. Have they passed the tests under the chapter? That is the question that they have not answered. I know why they've not answered it. Because international economic law allows them not to answer it. It's a matter of the interest of the people, and the people must feed on something. They must make money. Once there is less money, the people will become agitated according to them. And you know, I mean, what energy means to the EU, it's everything. It's the oxygen. So you see, this is where we can say that the frontline conflict between climate policy, climate law, and trade law is situated. It's just purely a matter of that flexibility in switching genuine interest for the economy and genuine concern for the environment and the health of the people. So, if we are going to summarize what it looks like under the WTO environment, trade liberalization is imperative, but not absolute. Does the same provisions that we have under the general exception provide an escape? To some extent, yes. But the escape is very narrow, too narrow for us to rely on it. Why? Because state must have to demonstrate necessity. And demonstrating that is actually fluid. The fluidity in the argument is so that we can't rely on it. And the strict adherence to discriminatory application also is like giving us one thing, opening the door to the right, and turning around to close the door from the other side of the room. That is the challenge that we have with WTO system when it comes to integrating environmental concerns. The second pillar, which is the international investment law. Well, the international investment law, because we don't have, like trade, we don't have one single global, instrument per se. Countries, they negotiate their investment interest. Oh God. They enter into bilateral treaties, and then they talk about what is there for us in your market. I am sorry, please, I'm going to do something that I've never done before, and it's because it's very important I do this. I'm the only one at home with my 8-month-old daughter, and she just woke up now because my wife is on night shift. So can you just excuse me for 3 minutes to just go and pick her up? I will bring her here, but I may have to shut my camera.
No issues, sir. You can take a break for 10 to 15 minutes. No issues, sir.
We'll take some few minutes off,
Okay.
Dennis. Yeah, it's fine. Yeah.
Thank you. Let me clear it to her. Thank you. Oh, God. Okay, let me do this. How do I switch the camera now?
Sir, you
Yeah, I just have to go and pick her. Don't worry about the camera. Let me go and pick her.
okay. Ma'am, shall I stop the streaming?
Yes, Dr. Tejayanta, I think we can just interrupt you for a while.
We cannot interrupt. There will be 2 videos. We can only stop it.
Okay, yeah, we can do that.
Mary, just hold on to me. See that he was busy. I'm sorry for coming to pick you late. Just be patient a bit.